This matter is entitled TJ Pine Valley Place versus Kevin Stroop. This matter has been going on for a long time. Certainly feels like a long time. Mr. Stroop has had an ongoing, continuing problem with bed bugs in his apartment at Pine Valley Place. We spent much time in 2024 trying to resolve this matter, and I thought we got there, and then we didn't. The consent order was entered on February 21st of 2025, nearly a year ago, and the order had some conditions in it, but normally in these deferred orders, there's a clause that says if the defendant fails to comply with the terms of the agreement, plaintiff can file an affidavit of non-compliance and ask for enforcement of the termination of the tenancy. This particular order states in paragraph 10, if the plaintiff moves to reinstate this case, the defendant shall have 14 days after service of the notice of the affidavits to file an objection with the clerk. In which case they did file that objection on November 9th and asked for a hearing. This problem has been going on for too long. No matter who's at fault, this apartment is still apparently grossly infected with bed bugs. And the plaintiff wants to terminate the tenancy. Defendant's contention is that the plaintiff, that he did try or attempt to comply with all the terms of the order. There was a discussion of plaintiff simply starting over with a new termination case, but we're in the context of the original case, 241901. Ms. Larson's, what's your position here? Excuse me, I've had a terrible cold for a while and I apologize in advance.
No problem, Your Honor. It's that time of year. I've got a bit of a cough myself, so I'll apologize in advance. And I want to apologize to Your Honor as well. When we were last before you, I had asked the court for permission to appear via Zoom. I had an in-person hearing in Clinton County this morning that I barely made it back to my office to be on.
I must have granted it back then, so we'll do the best we can.
And I appreciate the court's accommodation on that. And I appreciate the court letting me have witnesses on Zoom today as well. Our position is, Your Honor, as you've said, is that this remains an ongoing issue, that despite best efforts by Mr. Stroop, we do not feel that he has complied with everything that he needed to do. And
I'm having trouble hearing you.
Oh, I'm sorry, Your Honor. I said despite best efforts by Mr. Stroop, we do not feel that he has complied with the requirements that Pronto is needing from him in order to get there to the point of eradication. Pronto has been back in numerous times, including as recently as yesterday, and there remains a large pest problem that is not being able to get to the point of eradication. So we are seeking to, unfortunately, have to move forward with the termination.
Ms. Bauer?
Thank you, Your Honor. I do want to state that at the previous hearing, I consented to plaintiff's counsel appearing by Zoom remotely. I did not consent to witnesses appearing remotely. I understand the court has granted that discretion. I want to note our continuing objection for purposes of preserving the record.
Thank you.
To address the matter at hand, Mr. Stroop entered an agreement. That agreement settled a case. Michigan law is pretty ripe with case law that settlement agreements are contracts, they follow contract law. And I want to put these on the record because I didn't include them in my written statement either. So for example, Waldbridge, Aldinger Company versus Walken Corp., a 1994 case, and In re Conley Trust is a 2024 case. They both point to settlement agreements being strictly subject to contract interpretation law. Second, Mr. Stroop agreed that the bed bugs were bad. He agreed that he wanted to get rid of the bed bugs. He agreed that he wanted to help get rid of those bed bugs. And nowhere in this agreement did he agree that they could reinstate this case if the plaintiff or its for-profit management company, KMG Prestige, failed to get the bugs, quote, to point of eradication, as my colleague has said. He did not agree that they could evict him in this process if they failed to fully eliminate the problem. He agreed instead that even though the plaintiff and his management company have a duty to keep the property in fit and reasonable repair and to provide for proper, effective, and efficient pest control, that he wanted them gone so badly that he would pay for it, even though it was plaintiff's duty to do that. So the only question before you today, Judge, is, did Mr. Stroop facilitate the all-inclusive thermal remediation package? Did he comply and enable them to administer that treatment? And the answer to that question is yes. Whether plaintiff or its, again, for-profit management company, KMG, ensured that this pest control company from 3 hours away did what it was supposed to do is not Mr. Stroop's fault. If we proceed to proofs today, you will see that Ms. Alcala is not licensed to administer under state of law, under the state of Michigan. She's not licensed to administer pesticide. You will see that there were units disconnected from Mr. Stroop's building that have rampant pest bed bug infestations, entirely independent from Mr. Stroop. You will see that there were bed bugs in neighboring units immediately preceding the heat treatment that Mr. Stroop and his care team through ACT facilitated. The treatment they facilitated, you'll see that there were infested units connected to his that were not treated concurrently. You will see that Pronto Pest Control administered steam treatment that presumably Mr. Stroop paid for in a different unit, but never in his unit. You will see that the only areas of his unit that they tried chemical treatment on did not cover the full facility. And you will see that he wants this issue taken care of desperately and has tried to facilitate that happening. He did not give up his right to a trial on the grounds that he could be the scapegoat for KMG and Pronto failing to contain a pest issue at this entire multifamily housing complex with multiple buildings. You'll also see that upon notice of the presence of bed bugs in units, KMG or Pronto allowed sometimes up to 2 weeks to go without any treatment in those units before addressing that issue. So the fact that they have an ongoing bed bug issue does not mean that Mr. Stroop violated what he agreed to. In terms of landlord-tenant settlements, this is a little bit of a complicated settlement. In terms of contracts, this isn't that complicated of a contract. It specifically outlines what Mr. Stroop agreed to do and what the plaintiff agreed to do. The plaintiff agreed to contract for an all-inclusive thermal remediation package. I asked for that contract, I never got it. The plaintiff agreed that they would notify Mr. Stroop, members of his care team through ACT, and myself for all treatments related to that all-inclusive thermal treatment package. The agreement distinguishes subsequent routine treatments to happen at the facility. Failure to comply with those routine treatments did not provide a basis for reinstatement in this case. It did not provide a basis for evicting Mr. Stroop. The only basis for reinstating this case, which is a requirement of the Michigan Court Rule. Michigan Court Rule requires that the conditions for reinstatement must be clearly set forth in the settlement agreement. And those conditions are that Mr. Stroop would comply and facilitate the all-inclusive thermal remediation package. His care team is here today to testify to their conversation, to being present, I should say, on the day of the thermal treatment to ensure that his unit was prepared and ready to go and to address any outstanding issues that may be needed, but there weren't any. His care team will tell you that they went so far above and beyond to help eliminate this problem that they've procured entirely new sets of clothing for Mr. Stroop and had him stripped down before entering the place he was going to stay and put on brand new clothing so that he didn't potentially reinfest this unit. Did Mr. Stroop violate this contract? He did not. Did TJ Pine Valley Place or its for-profit management company, KMG Prestige, do everything that it agreed to do? No. They do not come to this court with clean hands. They don't even come to this court with a basis for reinstatement under their own evidence submitted. Yeah, they've got a problem, Judge. That problem is not Mr. Stroop. Certainly not in isolation. Mr. Stroop has suffered and tried to facilitate cooperation because his life depends on it. For that reason, we ask that you leave this case dismissed and plaintiff can proceed if it wishes, and Mr. Stroop can proceed with his other legal avenues as well. Thank you.
Got my pages out of order here. It would have perhaps been cleaner to start from scratch, but from everything I've heard through all the testimony in this case, Mr. Stroop is part of the problem. I think I just watched him take a bed bug off his hand, seated at council table. He's very dirty and disheveled and has a difficult time living independently. And he is round zero of the bed bug problem. I quoted from the order, and then I went to find what I quoted for. I can't find it. It's in paragraph 10. The affidavit filed by the plaintiff there we go. Indicates that it's an attachment B. They used the heat treatment on March 21st, 2025. On March 26th, they sprayed the baseboards and continued to find bed bugs. On April 9th, the defendant was unable to allow testing because he was ill. April 23rd, they sprayed furniture and baseboards and they were still found to be there. May 5th, they sprayed the furniture and bed bugs. They were still there. May 6th, sprayed furniture and baseboards. They still found them. Each time they recommended the defendant launder his backpacks and duffel bag. May 27th.
Judge, may I address the court?
Yes?
Thank you. I would first like to object to the court's referencing the attachments. The affidavit itself is actually only 2 pages long. They reference additional documents that are rife with hearsay and inconsistent with the documents that I received, slightly at least, but inconsistent nonetheless with the documents I subpoenaed from Pronto Pest. I would also like to point out that in each of those dates that you just mentioned, although there's a slight contradiction on one of them, on April 26th, he cooperated and they sprayed. On April 23rd, he cooperated. The unit was prepped sufficient that they could spray. On May 6th, he cooperated. The unit was prepped such to witness.
We're not in argument yet. I'm just reciting what's in the affidavit. So sit down. They continued to spray through September. Hundreds of all sizes. And so all through the spring and summer of last year up until recently, they've continued to attempt to treat this. All right. Now, Miss Larson, Ms. Bauer makes the argument that this is a contract and you're arguing that he failed to comply with his terms of the contract. The plaintiff's obligations are set out in 2, 3, 4 paragraphs. Defendant's obligations start at paragraph 5. Defendant shall fully comply with the attached 3-page bed bug heat treatment instructions. Defendant shall continue to remit $100 per month above his monthly tenant portion to pay for the treatment. Defendant 7. Defendant shall have the right to remain in possession of the premises unless he fails to prepare his unit as set forth in this order. The parties agree that if Mr. Stroop fails to prepare his unit as set forth in this order, then plaintiff may reinstate the case and seek simultaneous entry of a possession judgment. So that's really what this boils down to. You're alleging that defendant has failed to prepare his unit as set forth in the instructions, and I guess the defendant contends that he did. Is that accurate?
Yes, Your Honor, that he did not fully comply and therefore it has prevented the eradication that I think everyone was contemplating. And
It's not just me. None of us can hear you very well. I don't know if
I'm
it's your
sorry, Your Honor.
microphone or you're not close enough. It's also very dark in there.
I can try and make it a little brighter. I don't know if that helps any, Your Honor. I did try to move my
Yes.
microphone closer.
All right.
That is our position, Your Honor, is that Mr. Stroop did not comply fully with the requirements that Pronto needed from him, and that the bed bugs have not been eradicated and are either being reintroduced or the problem is growing, and that is what is contemplated on the attachment from Pronto.
Who is your witness for that?
That's Trisha Alcala.
All right, Miss Alcala, would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes.
And will you state your name, please?
Yeah, Trisha Alcala, Vice President, Pronto Pest Management.
Could you spell your last name for us?
Alcala.
Miss Larson, you may inquire.
Thank you, Your Honor. Ms. Alcala, how long have you been the Vice President of Pronto Pest Management?
About 7 years, 8 years.
And were you otherwise employed by Pronto before that?
I've been working there since 2014.
So 11 years in pest management?
Correct.
Any experience in pest management before 2014?
It's a family business. Dad built it since 82.
So how many years total of experience do you have in pest management?
Oh, dear gosh. Growing up, took a break, moved to Marquette, moved back here in 2014, 15.
Thank you. Are you familiar with Kevin Stroop and his apartment?
And working with him for a very long time, even before of 2024.
So a couple of years?
I'd say probably about 3, if not more.
How many times do you think that you've been in his unit?
More than a handful. I can't say offhand. I've helped him tremendously. We've eradicated his problem. On top of that, I've even helped voluntarily on my own time clean his apartment. I mean, I've done a lot of work and worked with him specifically, patiently.
You're familiar with the heat treatment that we're discussing here today?
Yep. Thermal remediation, correct.
How normal is it to have to do thermal, is it remediation? Am I saying that right?
Yep, remediation. So for heat treatment, most of the time if a unit's infested, the heat treatment's designed to bring the numbers down to a controllable manner. And after that, that's usually when the chemical treatment will come in, as well as the steam treatment to help finish and eradicate the problem. So, but because of his ongoing issue, we also have dogs that sniff them out. Sometimes we'll bring a dog in depending on the situation, but because of his situation, as well as some of the clutter that's been going on, as well as the ongoing issue, we went in and did a visual, and we instead decided to do a chemical treatment. That would be me and Susan. I went in, I did a visual with her. She's the one who chemically treated.
Okay.
All right, when was this?
Ooh, I was right after the heat treatment. I believe it was on 3/26/25. The heat treatment was 3/21/25, 3/26/25. Sprayed baseboards as a lifted carpet to spray under.
Objection. Your Honor,
Yes?
I believe she's referencing something that has not been admitted to evidence. I cannot be certain
no?
what she's referencing while testifying.
The service report of 3/26/25.
All right, well, what are you looking at?
The
It's hard to
service,
tell.
there was a service report given by us on 3/26/25.
I believe those are part of the documents that Ms. Bauer has subpoenaed, and she has those records.
Correct.
So if you need those, Ms. Alcala, to refresh your recollection, please let me know and I can ask you to look at that
Okay.
document. I don't want you to read from it.
All
I
right.
just need to refer to a document.
Yep.
Just let me know you don't recall and I will ask you to refresh your recollection. You let us know what document you're looking at. If it's something
All
that
right.
you haven't provided to Ms. Bauer, I need to know that.
Everything that has been provided, Ms. Bauer, is everything that she has that she subpoenaed for.
At this
So-
point, Judge Defense would like to renew its objection to virtual testimony for exactly this reason. Yes, I have documents. I have lots of documents, but I don't know exactly what she's looking at when she's talking about it.
There is some legitimacy in that. I allowed Miss Larson to appear remotely and then ex parte at 11 o'clock this morning. I was asked whether the others could appear remotely. It's very difficult to exchange exhibits, see what they're doing.
Okay.
And defendants objecting to the remote testimony of the defendants.
It's not my intention, Your Honor, to necessarily introduce every single one of we'd be here for 4 hours, probably more.
Oh, we could be here for more than 4. We could be here for 4 days.
Yes.
But
I wasn't intending on introducing them as an exhibit. I think Ms. Alcala would be able to refresh her recollection as needed if the court is looking for a particular date or something, but I would not, I do not intend to have her testify directly from the documents.
I don't want to do this twice. Miss Alcala?
Yeah.
We're gonna have to come back. But is part of the problem in this matter the way in which Mr. Stroop maintains his apartment?
Yes.
Tell us about that.
He has heavy amount of clutter. We have encouraged him to wash and dry his clothing items as well as vacuuming, preparation wise, as well as, any dead ones that I've seen. So, but it's just encouraged and it has not been done. According to my 2 technicians that have been in there, and when they report back and talk to me about it, he has not complied with the preparation sheet at all.
That's another problem, Miss Larson. We're going to get into hearsay by what the other technicians told Miss Alcala. And I'm certain that Ms. Bauer is going to object. So the other problem is I don't think we have all the witnesses we need. Some of the reports refer to how filthy this apartment is. And the heat treatment exacerbated all the terrible smells in there. But a lot of those treatments are done by different treatment providers. And I don't believe Miss Alcala can testify to what the other treatment providers told her. Miss Pennington's got boots on the ground and she knows things and she's seen things. So she's self-contained.
I understand, Your Honor. I understand the hearsay issue. I would beg the court not to have me have all of those witnesses in person for the sake of Ms. Alcala's business. They're 3 hours away. And to bring in all of her technicians would be a significant, I presume, a significant impact on her business to have her entire operation basically shut down for a day.
I'm guessing it would. This is conflict between the rights of this tenant to maintain his tenancy and the rights of everybody else who lives in Pine Valley Place. Mr. Stroop says, I don't want bed bugs. I'd like to get rid of the bed bugs. But I don't think he has the wherewithal to get rid of them. Pine Valley Place says, we shouldn't have to put up with this. We've been at this for 3 years. His apartment is filthy. He's got bed bugs. We've spent thousands of dollars and hundreds of hours to remediate it, and we haven't been able to fix it. And we don't want him as a tenant. Mr. Stroop is protected by certain protections over and above a normal tenant and a normal tenancy. So they can't simply move to terminate the tenancy for expiration of the lease. They have to show just cause. The ACT team has been involved throughout. Have there been any efforts to find other placements for Mr. Stroop? This is an unsworn witness, but someone that's here, his ACT team worker. You can just acknowledge if there have been efforts?
Yes.
Okay. And a concern had always been, this has sort of been a placement of last resort. If he were evicted, he'd be standing out on the street with nowhere to go. However, he does have the ACT team in his corner from Pivotal, and that's always been reassuring to me.
Judge, may I address the court?
Yes.
The ACT team has been constricted in their ability to help Mr. Stroop because of KMG Prestige's failure to eradicate the bed bugs in this property. They also, I guess I'd like to point out, 3 hours away is a very far place for a pest control company to be. They don't want to bring their witnesses into court, but there are concerns that if they've been doing the same thing over and over again for 3 years, that perhaps they're not the best pest control company. Has anything different been tried? And the answer is, other than the $1,300 that Mr. Stroop paid, Mr. Stroop was unlimited, it fixed income, $1,300 he's paid for this thermal treatment. Nothing else has been tried.
Your Honor, if there is some implication that my client is doing this intentionally, that is preposterous with the utmost of respect to Ms. Bauer. My client has nothing.
I think so too. I think so too. The whole thing, and I'm going to block out 12 weeks of court time to take testimony on this. I'll block out February, March, and April to have exhaustive testimony on whether or not he cooperated. And so the whole thing rises and falls on the enforcement of that paragraph 4. Oh, excuse me, paragraph 7. That Mr. Stroop fails to prepare his unit as set forth in this order.
Judge, may I inquire of the witness that may actually help you make a decision?
Yes.
Ms. Alcala?
Yeah.
Did you or your company sign a contract with Pine Valley Place for the administration of an all-inclusive thermal remediation package?
It's based on a proposal. There is no specific contracts that I'm aware of. We don't, Pronto Pest hasn't really done any specific contracts.
So there was a heat treatment done here twice, just once on the 21st?
I believe
Yes.
that's correct. Yes,
Okay.
Your Honor.
And so that's the next question. Did a heat treatment, were your technicians able to administer a heat treatment in Mr. Stroop's apartment on March 21st?
If the paperwork, do you have the piece of paper? Was there a service report?
Your service report indicates that a heat treatment was able to be conducted on March 21st, that the unit was prepared. Is that accurate?
Well, without her being able to look at the, I would
Well,
object.
she
to
can
counsel.
look at it, just as, was a heat treatment administered in this apartment on March 21st?
He heat treated the apartment.
Who did it?
Yes. Rob Bedia, he's our heat technician.
All right, so obviously he's an important witness. Is it your contention, Ms. Bauer, that they never actually did a heat treatment?
It's my contention that they scheduled a heat treatment and only a heat treatment, that they administered that heat treatment. So either Pronto, Pine Valley Place or KMG did not actually do as they agreed to do, which was to contract for an all-inclusive thermal remediation package, or all they did, or all that is part of that all-inclusive thermal remediation package is a thermal heat treatment, and that Mr. Stroop facilitated the administration of that heat treatment. So either there is a full contract outlining more than heat treatment, but there isn't, or there is no contract. So the only thing at issue is, were they able to heat treat the apartment? And the answer to that question is yes. So by the terms of the settlement, he fully complied with the attached 3-page instructions for thermal remediation.
I'll object. That's counsel's argument, but that hasn't been, that's contrary to the witness's testimony.
All right, this is bad. I can't hear you.
I'm sorry, Your Honor.
Have all the witnesses we need. Defendant contends there's some fundamental defects. It would be much simpler to simply file a new notice to quit. And all this testimony could be used then to show why they wish to terminate the tenancy for just cause. Now, we're in the posture of negotiating under this stipulated order. Did the plaintiff do everything they were supposed to do? Did the defendant do everything he was supposed to? I don't know. If it was simply a termination of tenancy for just cause, then all of that evidence could come in as to every time they treated the place, they still had bugs. It isn't whether or not he cooperated with the agreement. It is, does he continue to have bugs? So right now we're in a little bitty box. And there's a lot of stuff that's outside the box.
I
can't
really
hear-
want this over for my client, Your Honor. I to be in full candor to the
Well, I
court,
certainly agree with that.
yeah. I did
And
file, or excuse me, I'm sorry, Your Honor.
go ahead.
I did serve a new notice to quit on Mr. Stroop after the last hearing. That deadline, I think, just elapsed maybe like right before the holiday. I did not want to have to delay this hearing though, Your Honor, in filing a new complaint. With respect to Ms. Bauer, I think that she's assuming that an all-inclusive thermal remediation package is something different than a heat treatment. I think I can ask the witness that question, where she's parsing through things here, Your Honor, that, you know, are in my opinion, technicalities that probably don't exist.
Well, we wouldn't have to deal with that if we weren't dealing with the stipulated order.
Yeah.
Mr. Stroop, have you received a new notice to quit? Did they serve on you? Who did it? Ms. Pennington, did you do it?
I did it, Your Honor.
All right, what was the date of it?
October 21, 2025. And I believe we mailed that directly to Mr. Stroop. I think we sent a copy to Ms. Bauer as well. I think we emailed her a copy.
Which means you had until November 21st to vacate, or you'd be subject to the filing of a termination of tenancy case. So the month has passed. All right. We can't proceed today. We can't hear the plaintiff's counsel very well. We don't have all the witnesses. Counsel objects to the ex parte request to allow defendants or plaintiff's witnesses to appear remotely. So we got multiple problems. And as I said, I don't want to go all through this and have it overturned on appeal for technical problems. I certainly don't want to do it twice. We have a, I don't know, solution, because we're still going to have to take testimony, but we weren't in this little box. Mr. Stroop, they want you to move. They have for a long time. I'm not sure why you haven't moved already. You've been bit by 10,000 bed bugs, and it's been very uncomfortable for you too.
Judge, there's a more complicating factor on why he hasn't moved. The plaintiff threatened him with
No,
eviction.
objection, Your Honor. No,
Stop. All right.
Get rid of his housing choice voucher.
Objection.
All
Your
right.
Honor.
All right. I don't know the answer to that, but that's not even relevant. But I think you need to be in a place where you have assistance, a group home or assisted living someplace. But I'm not an expert on that sort of thing. But I know we can't proceed today. Counsel objects to the defendants appearing remotely. We don't have all the witnesses we need, and there is a looming notice to quit. And I would suggest we do this in the context of that. Plaintiff has 21 days to file a termination of tenancy action.
My assistant may be for this, Your Honor, but I believe we could probably even file that as quickly as today.
All right, I'll give you 7 days to file a termination of tenancy action. Then we can schedule a termination of tenancy hearing that probably would not occur until January. And if I adjourn this hearing, it isn't going to occur till January either.
Can I ask, Your Honor, would we be scheduled for an immediate trial, or would we have to do a pre-trial and come back for a trial?
Well, I have to do the first hearing. I have to adjourn it at least 7 days. So we would have the first hearing and then schedule a trial from that. Now, at this point, Ms. Bauer doesn't represent the defendant in that case because it's going to be a brand new case with a brand new file number. But I suspect she's in for the long haul here. That would make it easier. If I've got to take a testimony anyway, I would rather do it in the context of a termination of tenancy case rather than whether or not this is a violation of the stipulated order. So if it's filed today, the notices will go out. If it's filed within the next 7 days, defendant has an opportunity to respond. We'll set a hearing. At the first hearing, we can even do it remotely. We will use that time to schedule a trial on the termination of tenancy issues for these violations. And we won't be limited necessarily to bed bug violations. There were hoarding allegations and some other things that came up in some of the earlier matters. Ms. Bauer raised an issue that might be a stumbling block to relocation, but those aren't before me. Yes, Ms. Bauer?
I apologize. I was just indicating he's not of order. He actually doesn't have, but it's irrelevant.
Well, he got rid of everything he owned, but in the early stages of this, the testimony was the department was quite cluttered and filthy. There have been ACT team, other people that have come in there and cleaned the apartment. I don't even, maybe we'll have testimony, but others have attempted to clean the apartment on multiple occasions. So I think he's a minimalist now because everything he owned, I think, has been removed, but there's still issues.
Understood, Your Honor. For purposes of a clear record, is the court denying the request to reinstate, but instructing the plaintiff to file under a new case number?
Yes, that would probably be cleanest. Court denies motion to reinstate the termination in 241910 LT, which will bring closure to this case. Plaintiff is directed to file a termination of tenancy action within 7 days.
I would just ask, Your Honor, that obviously nothing that is occurring in this case be used to prejudice plaintiff in the new case, that it would be a fresh start.
No, that we didn't get very far, but no. In fact, we'll be in a broader context in the termination case than we will be in this violation of the stipulated order. So nothing today would prejudice either the defendant or the plaintiff. We'll simply start fresh. All right, Mr. Stroop, they still want you to move. They're fighting vigorously to get you to move. Your attorney is fighting vigorously to not have you move. But if they prevail, your landlord, you're going to have to move. And so you may discuss that with your people that are assisting you. Do you need a bus pass to get back?
No, I just need a call to tell them they're supposed to pick me up here at 3. So,
County transportation?
yeah, St. Joe County.
Yeah, well, let me give you 2 passes so you can get paid for the fare.
I got passes.
Well, I'll give you 2.
All right.
All right. We will revisit this in the context of a termination of tenancy case. All right, thank you.
Thank you, Your Honor.
And we'll do the first hearing remotely. Ms. Larson, you or someone from your firm can appear at the initial hearing. But at that hearing, we'll be scheduling the trial and termination. We're going to do that live. All right, we'll be in recess.
Thank you, Your Honor.
Thank you, Attorney Larson.
All right, thank you. I will do that order, Ms. Bauer.
Oh, I'm sorry, Judge. Yes. Thank you, then. Let me check.
Thank you. Thank you. That's why I'm here. All right, good luck. I'll see you probably in January.
Thank you, Judge.